I have two parts of, or 2 pages from the Facebook pages, which we've introduced as Exhibit 5, and they're numbered, and they refer to Chief Maynard making contact with Sarah Williams, and it's her post. And then there's a post from Jervis Middleton talking about Sarah Williams and in their contact with Maynard.
I think for the record, I think Ms. Roberts misspoke. He actually did not introduce that. He labeled it, and then he never introduced it with Carol.
I know, I understand.
So if it's not introduced, then it shouldn't come in. In addition, I believe this violates my client's constitutional rights as far as confronting the witness. I mean, Jarvis Middleton's not testifying. In addition, it's hearsay. To include this to say somehow or another there's a personal insult towards this man individually, it's not even relevant. I mean, Mr. Roberts knows that it's not against the crime, against the law, to curse someone and yell at them and say a personal insult.
We're not talking about that on this.
Well, he's asking questions
that has
like,
nothing
you
to do
didn't
with
arrest people when he knows you can't arrest them because you have to violate the law. It's not a crime. So the issue is, what offense does this go towards? It can't go towards disorderly conduct. They dismiss a drug paraphernalia. It can't go towards a marijuana offense, so it has to go towards a rioting. And they've already articulated the basis for the rioting is that she made a statement saying we're going to escalate and then jump over a barricade and lay on the ground. What insult she made to this man personally is no relevance.
This has nothing to do with this, Daniel. That has nothing to do with insults.
What is the purpose of, what are you seeking to do, Mr. Roberts, by introducing this?
I want to show that this police department tried to help her manage this crowd, and she absolutely would not take that advice or help. She did not want it. She wanted to be a chaos.
Okay, so then they should charge her with the violation of the protest statute, not they be offered help. In addition, that's not relevant.
Well, it is relevant. It goes to mindset of what ended up on the 13th. And you've already ruled that we can introduce statements that she's made from the 13th or from the 1st all the way up to the 13th. And this is definitely a statement that's negative.
And this is how did you obtain this? Is through her phone?
No, that's her Facebook. That was on her phone, but we were able to, and we've introduced the whole thing. There's 4,000 pages of it.
No, we did not introduce that.
Well, hold on just a minute, Daniel. I try not to interrupt you, so can you just wait? So, like a medical record, Judge, if in a major trial of a medical record, you would introduce the record. It wouldn't go back to the jury, but you could take parts of that medical record to then introduce on the specific points that are important, like the broken arm or what the patient said. That's what this is.
Judge, first, that last exhibit where Carol was on the stand, they never moved to introduce that. He labeled it. They never introduced that as an exhibit. If they introduced that, I would have had a bunch of objections on 4,000-something records coming in that contains who God knows what. I made my objection. He went back. He asked some separate questions. He labeled it, but they never moved to introduce that as evidence. So I objected that it was even introduced first. Second, the whole reason why I filed the 404 sheet and all these notices is to talk about what other acts, what other crimes we get into. This court limited to actions that occurred south of Christian Church. You were very clear what we're getting into, and now we're getting into someone was spit on. That was not a part of their basis for that notice for prior bad acts.
Okay. Let me just make sure I'm understanding. Who is saying this?
Sarah. Well, I can't read it. I'm not saying.
I'm just trying to figure out who is saying what.
This is Sarah Williams' text.
Okay. And that is authored by Sarah Williams?
Yes.
He's going to testify to that?
Right. How does he know that?
How's he know it's authored by Sarah Williams? It says Status Police Chief Maynard.
Well, it's got our code there on the front, on the right posted. You see posted right above that? That's her code. I'll put on proof about that. But Daniel knows that this is her Facebook, Judge.
And this author says evidently spoke to someone's friend who managed to cooperate.
That's Sarah. I say you that. It has her name right above it.
And I'm also confused. I believe Wagner talked about not getting Facebook records or Facebook Lives and stuff like that. So,
What?
Wagner, the officer testified about Facebook yesterday. So now they want to say, this is Sarah, but you have to lay a proper foundation.
I'm going to give him I don't think he's laid the proper foundation at this point in time. I'm going to give you a chance to lay the proper foundation. I know you're objecting to it being admitted in its entirety.
True. So, in addition, that previous exhibit that he believes is is introduced. He never moved to introduce that.
Exhibit number 3, which was the Facebook post that you put up on the screen, is that right?
No, it's a thumb drive. It's number 5, I believe. Was it, look in the envelope, that we gave you, the brown envelope, what number is that?
The brown envelope. Is that Tyson Carroll's?
Yes, he never moved to introduce that. He labeled it.
Well, I can introduce it at the end of the trial if we move to introduce it. I don't intend that that's going to the jury, but in that packet, just like a stack of medical records, these papers are relevant to what we're talking about. And there's some others that she posted.
Is relevant as far as her not cooperating with the police?
And making allegations about what she's doing in this case and planning and so forth. Now, not these two, but I've got a whole stack of stuff coming. When she takes a stand, I'm going to level her with it.
Oh, that's for impeachment, but I'm saying this exhibit that's right there was never introduced. To say it's already been introduced or admitted, it was never admitted into evidence.
Well, it can be admitted now. I'll move to admit it. It's not going to the jury. It's not going to be going to the jury, but I move to introduce it. We laid foundation, we did it. So I move to, right now.
We would object to the introduction of this exhibit. One, no, it's an improper foundation to even move to admit it. Carroll did not say that that's his business records or he pulled a Facebook post or he had a warrant on through this
I think it's
to authenticate it.
I'm going to overrule your request to admit it right now. I think we have to call back Carroll and have a foundation.
Okay, I'll call somebody. I'll call another witness who's
I'm going to
presently in
allow him to
the...
try to lay a foundation as to this right now. I'm not making rulings at this point. Keeping it up here, but he's going to try.